Commercial properties include real estate used primarily for business purposes, such as retail centers, office buildings, industrial facilities, warehouses, medical offices, and multi-family developments with more than 4 units. These properties are subject to a distinct set of laws and contractual practices from residential real estate, focusing heavily on financial performance, disclosure, and due diligence. A letter of intent, LOI, is a common tool used in commercial transactions. It outlines the basic terms of a proposed deal, such as price, lease rate, contingencies, and due diligence periods, before a formal contract is executed. While typically non-binding, an LOI helps clarify expectations between buyer and seller, demonstrates serious intent, and serves as a roadmap for drafting a detailed purchase or lease agreement. Subcategories of commercial real estate. Business opportunity sales involve the transfer of a business's assets, goodwill, inventory, or operations, with or without the real estate component. For example, a restaurant sale may include equipment, name rights, and lease assignment. These transactions require clear disclosure of financial statements, tax returns, and licenses, as well as compliance with the Bulk Sales Transfer Act when applicable. Under common law, a seller's duty to disclose applies to all real estate transactions, including commercial. Sellers must disclose all known material facts that could affect the value, desirability, or use of the property. Failure to do so may result in liability for misrepresentation or fraud. Statutory disclosure requirements. ARS, Paragraph 36, 1681E, addresses swimming pool barrier disclosure. Sellers must disclose whether the property has a pool or spa, and whether a proper barrier, as required by state and local law, is in place. This disclosure applies primarily to residential and mixed-use properties, but can also apply when commercial properties contain private or recreational amenities. ARS, Paragraph 33, 1806, and 33 for 1260, requires sellers to provide planned community and condominium disclosure information when the property is part of an HOA or condominium association. The disclosure package must include the governing documents, CC&Rs, bylaws, financial statements, and details about assessments or pending litigation. This ensures that buyers understand any restrictions or fees that may affect ownership or operation. ARS, Procure 33 434-001, mandates disclosure of a notice of soil remediation when property has undergone environmental cleanup or remediation under ADQ oversight. The seller must provide written notice of the remediation and the extent of contamination addressed. This protects buyers from unknowingly acquiring properties with lingering environmental liabilities. Under ARS, Paragraph 33, 422, sellers of 5 or fewer parcels in unincorporated areas must provide an affidavit of disclosure at least 7 days prior to closing. The affidavit identifies the property's access, utilities, flood zones, water supply, and zoning compliance. Although primarily used for rural land sales, this requirement may apply to commercial parcels in unincorporated areas. ARS, Paragraph 28, 8484, requires disclosure if the property lies within a military airport area or its noise or accident potential zone. Similarly, ARS, Paragraph 28, 8486, applies to public airports, mandating disclosure when a property is within a recognized airport influence area. These statutes protect buyers from unexpected aircraft noise, overflight issues, or use restrictions. Under ARS, Paragraph 32, 2183, subdivision disclosures and public reports must be provided to buyers when the property is part of a subdivided or newly developed commercial subdivision. This statute ensures developers provide the same level of transparency for commercial land sales as required in residential subdivisions. ARS, Paragraph 32, 1121, governs contractor licensing and scope of work. It requires that any person performing construction or repair work on a property for compensation must hold a valid Arizona Registrar of Contractors (ROC) license unless exempt. Licensees must perform work within their specific scope, e.g., electrical, plumbing, roofing. Agents should verify that all work on a property was completed by properly licensed professionals to prevent liability for unpermitted or substandard construction. ARS, Paragraph 4B45101, requires wholesale disclosure in transactions involving the assignment of purchase contracts. A wholesaler who markets or assigns a property contract must disclose their status as an equitable interest holder, ensuring transparency to both the buyer and seller. This law was enacted to curb deceptive practices in wholesale real estate and applies to residential, commercial, and vacant land transactions alike. ARS, Paragraph 32, 11, 21A, 5, 32, 11, and 21A, 14, and 32, 1103 further detail contractor licensing exemptions and requirements. These provisions specify who must be licensed and under what circumstances. For instance, property owners performing work on their own property for personal use are generally exempt, but developers or flippers who build for resale must be licensed. ARS, Paragraph 32, 1103 defines the powers and duties of the Registrar of Contractors, including the authority to investigate complaints, suspend or revoke licenses, and enforce compliance with state standards. Buyer disclosure obligations under ARS, PR 445101. Buyers engaging in wholesale or assignment transactions also have disclosure responsibilities. They must inform all parties if they intend to resell or assign the contract to another party prior to closing. This transparency protects the original seller from being misled and ensures that the end buyer is aware of the contractual chain. Additionally, AAC R4 28 1101B requires full disclosure of all material facts known to the licensee that could affect the transaction. For commercial buyers, this means disclosing known zoning limitations, environmental issues, easements, or property conditions that could impact the investment's value or intended use. Collectively, these statutes and administrative rules ensure that commercial transactions in Arizona are transparent, ethical, and compliant. They balance the sophistication of investors and developers with necessary consumer protections, fostering trust and fairness in the state's commercial real estate market.